Yes.
All right, I'll call to order the Town of Mount Desert Planning Board meeting for May 22nd, 2024, and welcome aboard. All right, I'll make some introductions here. We'll get right into it. I'm William Hanley, Chair. We've got Vice Chair Tracy Loftus Keller. We've got Meredith Randolph, alternate member Ann Dalton, and Gail Marshall and Alan Kimmerly. And first item on the agenda tonight are some minutes to approve.
Yep.
And I think the first one we need to, Meredith, you and I need to vote on specifically for are the April 3rd minutes. And that was the,
I make a motion to approve the meeting minutes of April 3rd. Was written.
Tracy Keller, second.
all right. All those in favor? Aye. Opposed? All right, there you go.
And then May 8th.
And then May 8th, and I think we can pretty much all do that,
I don't think I.
except, yeah, I don't think.
Yeah, you were missing. Mhm.
All right,
I move approval of the May 8th minutes.
Tracy Keller, I'll second that.
all right, all those in favor?
Aye.
Aye. Opposed? All right, we got minutes taken care of. Other item on item 2 is item 2B, approve and sign statement of findings and conclusions for the Harold McGuinn Incorporated Freshwater Stone and Brickwork Incorporated Court Remand. And everybody's read our final findings and final conclusion of law.
Was there any reaction to the comments I gave?
I have not heard any. Talked to Collier today and, you know, he was good to go with us doing this tonight as is.
Did we need to announce that it was advertised? Is that what you're
Is this it here? This is it here. Yes, it was advertised in the April 25th Courier Gazette, Ellsworth American and Mount Desert Islander Republican Journal. And I guess it's just a one-time publication on April 25th.
And I can read this too, and just. It's myself, Meredith and Tracy that are the voting body on this and the quorum, so. And how this reads is it says decision, this is upon a motion duty made and seconded and approved, the board voted. To propose the additional clarifications to the original finding number 2 of the February 9th, 2022 original decision and additional clarification to the original conclusion number 1 of the same decision. And then it also says upon a motion duly made and seconded and approved, the board voted that based on the board's supplemental findings or clarifications of the original decision, the board affirms their previous denial of the application. And then it's got places to voting in favor and voting against, and looks like we need to first have a motion to accept the findings and the final findings and conclusion the board was made, and then we need to sign this thing.
This sounds silly, but do we need to read it into the record?
Do you?
I don't know the answer.
No.
To that. Okay.
No. So we need the motion to accept our
Findings and conclusions of law.
final
As read.
as written.
Okay, I, Tracy Keller, make a motion to find in favor of the findings and the.
To accept
To accept the findings and
final
final findings and conclusions of law for this matter,
as written.
as written.
I second that.
Any further discussion? Okay, all those in favor? Aye, opposed? Now we get to sign, so we sign our names and then we date it. Right up.
Oh, well, thank you. Somebody must work at the bank.
We might. Oh, you're next. You're next.
You took on that I gave you guys.
Oh,
What's, which,
What's the
It was
difference?
a while out, it was, never mind, sign it.
That doesn't even work.
it's dried up.
Mhm.
This is everything.
It's got a special ink. It's got a tip on it. We all had matching pens.
22nd.
mhm.
Yes. And what would you guys think about accepting the chair's recusal and for a person now?
We need a motion for that?
I think so.
I
Yeah.
move we accept the chair's refusal for personal matter.
I second that.
All right, all those in favor? Opposed?
One by
Thank you.
stay here.
Be going with you.
And then, so you guys gotta go for, well,
Well, frankly, do we actually, do we have anything to discuss?
No.
The rest of us were there.
Yeah,
Yes, I
it's-
think that's correct.
Yeah,
Um,
so we just have to sort of
Would
just
you
generally
want-
discuss it.
do you wanna fill Ann in if we use?
we can,
Yeah,
we can.
Yeah,
right.
but go for it. Nan.
All right. So do you wanna?
Yes.
Yes.
Let me get out of here.
I have one.
Yes.
Well, do you want me to explain the continuation of the postponement or?
Yes,
Yes,
yes.
please.
Wait a minute, do we wanna make her, you wanna make you a voting member?
And we
Do we
need
go
to,
ahead?
I know.
Okay,
We're just discussing.
yes, okay. We can make that right.
Okay,
So, well, the vice chair would be taking over, so it's Tracy.
Yeah.
Right.
yeah, so I'm gonna be the conductor of the meeting from here on out, but, so yes, we would like an explanation of the, whatever you said about the condition,
Postponement?
yes.
Yeah,
Yeah, this application came in, and the Astuku owns various lots around the Astuku Inn or Astuku Hospitality.
Yeah.
And when they submitted their application, they combined lots to, in the site plan that was not legally merged. They had to be deeded to be merged, and that wasn't done. And so I explained to the agent that they either have to file 3 separate applications, which in your packet, you're gonna find once you get it. The first page of the conditional use application is 3 pages for the 3 separate lots. They were under the understanding that because the lots were not conforming due to the lot size, that they were automatically merged, but with non-conforming lots in the same ownership, if there's a principal building on the lots, you're not required to merge them. If they were vacant, then they would be merged. But the deed also indicates there's like 5 to 7 lots in the deed. So they asked for a postponement because we had met via Zoom to talk about this because they were proposing development over an interior lot that was not merged with the mothership lot, if you will, yet. So they have to have it deeded to be merged, and that's why the postponement, is because they didn't believe they'd get the deed in time for tonight's meeting.
Mm.
So they asked to have it postponed to the June 12th meeting.
thank you.
And it's quite a development that's occurring.
So this, I see they're doing all sorts of work on the hotel itself.
Yep.
Is this other stuff?
Oh, yeah, I'll show you a little quicker site plan, but, they've got the initial in, they haven't added any rooms. They're just bringing it up to code and also installing, an elevator that actually people can fit in versus a phone booth, so. No work has been done in that end for years.
Yeah.
So it was ideally falling apart on them. It's just a quick overview, whoops, sorry. This is what they're proposing.
So here's the existing one.
Correct.
Pool and guest rooms.
What's the lower two blocks there, below the inn?
No, this, all this area now is this.
Right, yeah.
And then the octagon,
Pool and guest room and guest rooms and.
yeah, and this is the octagon. Just to give you a quick overview, don't discuss it.
Yeah.
I'm just showing you.
Private.
Okay.
Yeah. So
Pool and guest room, what, you can't have, guest rooms in a pool, what is? Adjacent to it.
What, how many, is this 2 levels? Is the pool on a lower level?
We'll figure it out.
Oh,
Oh,
we're
yeah,
not just-
there's
I mean-
the square, doesn't make
Just-
sense.
Well, you'll see it in your application.
Yeah,
But that's just to let you know. So what they were doing is merging this lot. And then this lot right, sorry, hang on, I gotta see. Then this lot right here. Yeah, is where the octagons are. Yep.
Mhm.
Yep.
Yeah. That's it.
wow,
That's big.
yeah.
Okay, a helicopter coming down. Put it in the backyard.
Thank you for that. And if you read about 50 pages a day between now and 2 o'clock. you can-
You folded it right back up again.
Yep. You'll get one before you guys leave tonight.
Okay, all right, so that's that component. And then, under section 4, we have, other update from the land use zoning ordinance advisory group.
Well, we had, a spirited discussion, which I think is a work in progress about numerous items. We talked about, let me pull up my minutes that I wrote for. Kim, would you now share the minutes that I wrote, for the Luso meeting? How will you do that?
Me?
Yeah, how would the notes get distributed to the committee? I mean, we don't usually get minutes, but
We don't usually get them, but yeah, I can, send them off to everyone.
yeah, it'd be nice if,
Yep.
um,
Do you see my edits that I had?
I'm just looking at them now. So,
I did add the Zoom,
thank you.
yep, caller, and then
Yeah, thank you.
minor tweaks.
Good. So the first thing was we were gonna recap the town meeting results, and that really wasn't much of a discussion because all the Luso ordinance provisions that were on the town meeting passed without. Right. And so we just moved on pretty quickly from that. The maximum lot size discussion. No, I attached to these minutes that I wrote the piece that I wrote after the prior meeting. Katrina and I were gonna meet and talk about how one might tackle that issue. And then, so after we did that, I wrote up a piece, and then Katrina got a chance to eventually look at it, and then okayed it, and then I shipped it to Noel and Jerry, and I didn't send it to Kim, I just sent it to Noel and Jerry, thinking that it was not my place to like start sending that around to everybody. So at this point, I am gonna include it, I have included it in the minutes, but basically, so we haven't really discussed that. Noel has not been able to find any, other ordinances that have provisions like this as guides or basis for discussion going forward. So we're not. We're not yet we're not in a position to call it in limbo, but we're not yet in a position to figure out how to approach it. So it went back it'll go on the agenda for next meeting. And hopefully people will have had a chance to consider how Katrina and I had kicked it around. I just really wanted to meet and understand what she was interested in. And that's, cause she's generating the interest in this. The table of allowed uses, we all got, proposals for a change table of allowed uses and definitions. And new definitions. The reason for considering this is that right now, the table of allowed uses in the zoning ordinance has lots of different categories, like commercial use and residential and it gets to be. It can get to be confusing and it can get to be incomplete, and one approach that Noel has done a bunch of work on and is proposing to consider. Is that we just expand the possible table of allowed uses. We kind of have them, we don't break them down into different types of entities who are applying for the application. And then we would have to go through those definitions and those uses, decide which ones of them we wanted to propose the town have in the table of allowed uses. Decide whether or not and if so, which zones in the town you'd want to have. Those allowed uses possible. And the one he kept bringing up was one of the definitions is animal husbandry, piggery. And he was saying, well, I don't think that's too hard, But so the question is, how much advantage do we think it would be to in some ways, in this way clarify the table of allowed uses? And would we also want to say that if something isn't in the table of allowed uses, the town does not intends for it to not happen? So piggeries, if we didn't put it in there and you had a provision in the ordinance that was inserted that says if it's not in here, you can't do it, then piggeries wouldn't happen.
4 or 5 years ago, Beach Hill Farms,
Ah,
COA did have piggeries.
yeah,
But doesn't that fall under animal husbandry?
well, it might fall into animal husbandry if we wanted to break it down, but I think then my guess is that the notion, it's a guess, is that a piggery is sort of a separate entity from keeping
Having to do
maybe
with
cows or
scale.
chickens or sheep or.
How do you do what?
The scale of operation.
And the scale of
Oh.
operations are different, so you could have,
More like an industrial lot, it's not just having.
yeah,
pigs.
like a concentrated feedlot or something. Do we want to concentrate kegs in town? We want to allow those. Or another one is outdoor entertainment venues. Do you want a provisions where small entertainment venues are allowed? Do you want provisions that would allow larger entertainment venues? And if so, where would you want that to happen? So that there is a bunch of that in there too, the larger, smaller kind of thing that tries to deal with scale. Again, he has said it's a rough draft, and if reading it, you can see that it is a rough draft, and it's got lots of blanks, for example, because if you put new uses you gotta figure out where you want them, and that would be something that discussion would lead you to, like, what do you think we should propose? So that is obviously also going to be discussed again going forward, and the hope is that everyone who is going to participate in the discussion will have a chance to have digested the 37 pages of definitions and the table of allowed uses and be able to talk about them in more detail going forward. Luso, section 6A compatibility, our favorite topic. Noel is, I think it's pretty clear, he's advocating that provision should not be in there. And there's a considerable divergence of opinion about whether or not it should be. And I think that is worthy, and I'll just say, I think that's worthy of ongoing discussion. Cause I actually think it's about much more than just we have differences of opinion. I think it would be to our advantage and the town's advantage for us to get further good advice. Because about what one should and shouldn't do as a planning board in interpreting and approving or denying applications. I mean, there are sections in the Maine Municipal Association manual, I think it's on page 46 or 47, about vagueness. And how much, to what extent do we fear or feel that 6A or 6.7 might run afoul of, in the same way that various other provisions at times have before the state law court. So to me, it isn't a matter of, I mean, opinion matters at some point, but I think there's more that we can do to try to establish a baseline of facts about how to interpret laws and statutes, and we're not. I mean, I may have gone to law school, but I'm not a lawyer. I haven't been a lawyer in a very, very long time, and I never did this work. And there is an advantage to that for sure. But our job is inextricably bound up in making findings of fact and conclusions of law. And that's what, I don't want to overstate what we do at all, but that's what judges do every single day. And that is our job in this venue. Judges do it in this venue. We do it in this venue. So the better we can become at figuring out what that means and what the law is and how it has already been interpreted by the courts and so forth, I think the better, not only for us, but for the community that has a right to come to us with reasonable expectations about what's going to be applied in when it relates to their application. But I think that's all a discussion that we can continue to have. I would just hope that we could have it on a level other than just my opinion is this and your opinion's that.
Well, one of the things I've been thinking about that isn't really, you know, nobody else thinks this is a problem, so none of us have been sitting around thinking about the way that we do things. But as I was going over, I was thinking about if Alan wants to have over a 6-foot fence, he brings it to the planning board. There's not a specific criteria that he has to cross. He's not allowed to have a fence over 6 foot, but he can bring it to the planning board. And we can allow it. It goes into non-conforming lots, all the shoreline, like we constantly, like that you don't want us doing what we do. Because we are constantly, things are coming to the planning board. Do you want chickens? There's not a specific criteria. The chicken doesn't have to be kept a specific distance away from other buildings. You have to come up so that we can discuss whether everybody's okay with you having chickens. You can bring a fence. You can have a fence over 6 foot as long as everybody's okay with it. It's non-quantifiable and we deal with the non-quantifiable constantly. I feel like that's 90% of what I do, and I understand that you don't like it, but you're basically, I don't understand how we would undo what this planning board does if you want it to all be that there's specific laws and criteria, and as long as you cross those laws and you meet those criteria, you know that your application will get accepted. That's what goes to Ken.
We already have very specific criteria for fences and for chickens. We already have those, and the question is, has the applicant met those specific provisions? And we have those specific provisions, as Noel pointed out last night, for lot size and for setbacks and all of that stuff. And the question is, in addition to that, or on top of that, does the board, despite the fact that somebody may meet those specific provisions, does the board have a right to say, yeah, but is it too dense or something like that? And we have provisions about density, you know. That's my concern, that we have layers of specific provisions and then we have kind of like, yeah, but, and I'm telling you, the manual, the Maine Municipal Association manual, I think alludes to this, and all I would like to do is get some clarity about this. If the clarity advice is, no, you're fine, just relax, then good, right? But it is very important for an ordinance, especially a zoning ordinance, to include fairly specific standards of review if it requires the issuance of a permit or approval of a plan. The standards must be more than, quote, as the board deems to be in the best interest of the public, or as the board deems necessary to protect the public health and safety and welfare. That's a state Supreme Court case. It also is very important to have language in the ordinance instructing the board as to the action in which the board must take. It is not enough merely to say the board must consider or evaluate certain information. If an ordinance gives the board unlimited discretion in approving or denying an application, it creates two constitutional problems. It violates the applicant's constitutional right of equal protection and due process because it does not give the applicant sufficient notice of what requirements he or she will have to meet, and it does not guarantee that every applicant will be subject to the same requirements. It amounts to substituting the board's determination of what are desirable land use regulations for that of the legislative body, in our case, the town meeting. I just want to have as much clarity as we can about where the boundary is between our discretion as individual board members. And I mean, when I asked the question about whether or not council would have an opinion about this, it seemed pretty clear that people thought council might have an opinion about this, and I should like to know what it is. And I think we should take that, those to me are like the facts, and then, yes, of course, we apply our discretion and our judgment all the time. And that's what we're asked to do.
Gail, can I ask from what you were reading?
Yes, I was reading from the Maine Municipal Association's the planning board manual, and in my edition, which I think is 2017, it was page 46. It was vague ordinance standards is what it's called. So I don't know if other editions would have.
Can I give it to you?
Would have the same language. So that's where that broader issue comes up for me when I look at 6A versus all the other more specific provisions that we tick down through. It's like we do all the other provisions and we say, oh, but now let's look at 6A. And obviously, I'm not the only person who has some concerns about that. And I just think it's worth the discussion. It's worth us checking it out and making sure that we're on the right track. And I'm not trying to be the lawyer about it. I don't know. I don't know. And that's above my pay grade. So that's kind of, you got a taste of kind of what we went around on. And I think that will be back for further discussion on the agenda. The other items on the agenda for June, which will be a draft solar ordinance. The work plan that had been proposed was that we would do that in July and we would do subdivision stuff in June. And Noel is proposing that we flip that order and we'll do it that way. So we might see a draft, we should see a draft at some point of a draft solar ordinance from Noel, who's been working with the Sustainability Committee. The other agenda item for June is committee organization. Jerry has indicated, well, he didn't appear last night, and he sent a note to everybody saying, I could understand if you wanted a new chair, because I'm gonna be busy. I got in touch with him and said, so what are you saying, Jerry? And he said, I think I want to step down. And I said, from the chair or from the committee? And he said, from the committee. And he and Kathy are out like every other night, right? And they each have so many meetings and work that they've done. And it's a busy time of year. And that's what he told me. And I said, is there anything else that concerns you and that people should want to know about? And he said, no, that's where it's at. So he may or may not be at the next meeting, I don't know, but we'll have to figure that out. And on top of that, Joe, the day before that, Joe Renault had written to me. Joe apparently had become the secretary of that committee at some point, And he said, this is, I don't know if I'm gonna be able to come to these next few meetings. I would like to have somebody else be the secretary. Would you be willing to consider doing that? And so at the June meeting, we need to figure out, first of all, who's gonna chair it. And we need to figure out how we're ultimately the committee needs to figure out how it's gonna organize itself and who's gonna do the tasks that are necessary to be done. And so it should be a lively and full agenda. I think, and that meeting is, by the way, on the 18th.
June 18th, okay.
Yeah. At 5. Did I miss anything?
No, I think, all the Luso meetings are on the third Tuesday of every month at 5 o'clock.
Yeah.
No, straighten me out on that. When are those Luso meetings?
I know,
Just seem to pop up.
right.
No, they're structured.
Right. Does that conclude your presentation on
It
the?
does, thank you.
Okay,
More than enough, thank you.
so, our next, part 5 is adjournment.
I make a motion to adjourn.
I second that motion.
Okay.
I'm in agreement with Mary.
Right, right, the meeting is hereby